Can you make an agreement to sell pirated movies? Or can somebody make a document which restrains you from getting married even when you're not a minor? We'll find out in this video. As per Section 2, Clause G of the Indian Contract Act, if an agreement cannot be enforced by law, we call it void. As already discussed in our previous video, that to convert an agreement into a contract as per Section 10 of the Indian Contract Act 1872, you need free consent of the parties. Parties must be competent to contract. Lawful consideration. Lawful object. Agreement should not be declared void. Let's discuss about the other conditions under the Contract Act which declare an agreement void. Section 20. Mistake of fact. When both the parties to an agreement are under a mistake of a fact which is essential to the agreement is void. For example, imagine you agree to buy a rare comic book thinking it's a first edition as informed by the shopkeeper. However, at the shop, it turns out it's actually the second edition. Since the true nature of the comic was essential to your deal, this agreement becomes void. However, an erroneous opinion as to the value of the object forming the subject matter of the agreement is not deemed a mistake as to a matter of fact. What this means is that, suppose the shopkeeper quoted the price of the book to be rupees 1000, however, the actual price of the book was rupees 500. This mistake to the value of the book will not be deemed to be a mistake as to a matter of fact. Section 23. Object or consideration is unlawful. The consideration or object of an agreement is said to be unlawful if it is forbidden by law, is of a nature that would defeat the provisions of any law, is fraudulent, involves or suggests injury to the person or property of someone, or the court regards it as immoral or opposed to public policy. In all these cases, the consideration or object of an agreement is said to be unlawful, and the agreements based on such object or consideration is void. For example, suppose you promise to sell your friend a pirated movie. Selling pirated movies is illegal and therefore your agreement is void. Section 24. If consideration and objects unlawful in part. If any part of the consideration or an object of an agreement is unlawful, the agreement is void. For example, you and your neighbor agree to split the cost of renovating your shared garden, but you also agree to use stolen materials for the job. Even though part of the deal is legal, which is sharing the cost, but as you decided to use stolen goods for your job, it makes the entire agreement void. Section 25. Agreements without consideration. Agreements without consideration are void. For example, imagine you promise to give your friend a valuable watch as a gift and your friend doesn't promise anything in return. Your friend cannot sue you if you do not give her the watch, as this agreement is without consideration and is void. But wait, there are 3 exceptions. Agreements without consideration can be enforced. First, if it is in writing and registered. For example, you promise to give a house to your brother for no consideration. This is a void agreement. However, if out of natural love, you give your brother a house, but this transaction is put into writing and registered, this is a valid agreement. Second, it is a promise to compensate for something done. For example, suppose you helped your brother to clean the house, and after you had done the job, your brother pays you rupees 100. This is a valid agreement. Third, it is a promise to pay a debt barred by limitation law. For example, suppose your friend owed you rupees 5,000, but it has been 4 years and the law of limitation provides for recovery of friendly loans within 3 years. Your friend can voluntarily pay that money even after 4 years, and this will be a valid agreement. Section 26. Agreement in restraint of marriage. Every agreement in restraint of marriage except a minor is void. For example, let's say you and your partner sign an agreement stating that neither of you can get married. Unless one of you is still a minor, this agreement is void because it restricts your freedom to marry. Section 27. Agreement in restraint of trade. Every agreement that restrains one from carrying out a lawful profession, trade, or business of any kind is void. For example, you work as a graphic designer. Your employer can't make you sign an agreement that you won't work as a graphic designer anywhere else. This kind of restriction is generally void. Exception. In certain cases, like selling a goodwill of a business and agreeing not to compete in the same field, is not considered void. For example, if you have a bakery shop and you sell the business to a buyer, the buyer can ask you not to start a competing bakery business in the same vicinity for a certain period to safeguard the bakery business's goodwill. Section 28. Agreements in restraint of legal proceedings. Agreement restricting a party from enforcing his rights under the usual legal proceedings or limits the time for enforcing the right or discharges any person from liability is void. For example, if you lend money to a friend and they sign an agreement that says that they can never go to the court to recover the debt, this part of the agreement is void because it prevents you from enforcing your right under the contract. However, there are two exceptions in this section. Exception number 1. Agreements between parties to refer the dispute to arbitration is not void. Exception number 2. This section also does not apply to guarantee agreements of a bank or financial institution where rights are extinguished after expiry of a specified time not being less than 1 year from the date of occurring or non-occurring of the specified event. Section 29. Uncertain agreements. Agreements, the meaning of which is not certain or capable of being made certain, are void. For example, if you and your friend make a deal to share profits from your business, but you never specify how the profits will be split, the agreement lacks clarity and is void. Section 30. Wagering agreements. Agreements based on wager are void, and no suit can be brought for recovering anything alleged to be won on any wager. For example, you and a friend make a bet on the outcome of a coin toss. Betting on a simple coin toss is considered a wager, and such agreements are void. However, the section provides for an exception wherein if you both contribute to a horse race pool where the prize is worth over Rs 500, that's allowed under the exception. So these were the conditions for void agreements under the Indian Contract Act.